Great. Welcome to the regularly scheduled and final meeting of the Blue Ribbon Commission on the Future of the California Bar Exam. We are going to begin by taking roll, and then we'll move to public comment right after that. Devin, can you please take roll?
Susan Bakshian.
Present.
David Boyd.
Present.
Alex Chan.
Present.
Charles Dugan. Jeremy Evans. Jackie Gardina.
Present.
Brian Harrison. Dr. Henderson. Esther Lynn. Tracy Montez. Judge Reeser. Natalie Rodriguez.
Present.
Kristen Rossi.
Here.
Emily Scavalletto.
Here.
Karen Silverman.
Here.
Mylyn Spencer.
Here.
Amy Williams. Joshua Petrula.
Here.
We have a quorum.
Thank you. As I mentioned last meeting, the Board of Trustees adopted a public comment policy that applies to all sub-entities, including the BRC. So please bear with me. I'm going to read from that policy statement and set out the public comment guidelines. The State Bar of California welcomes public comment at all of its public meetings and appreciates listening to a wide range of viewpoints that reflect the diversity of California. These public comment rules are designed to ensure that members of the public may exercise their right to be heard, as well as ensure that the State Bar is able to fulfill its obligation to conduct business on behalf of the people of California in a timely fashion. Members of the public were encouraged to submit written public comment at least 24 hours prior to the start of this meeting. Written public comments received less than 24 hours prior to the start of the meeting will be distributed the following business day. Oral public comment, members of the public were encouraged to sign up to speak in advance of the meeting and will be called in order they signed up. Members of the public attending the meeting remotely will be called in the order they appear in the attendee list. Members of the public cannot cede their time to another speaker. It is not guaranteed that all who wish to speak will be able to do so. To facilitate hearing as many members of the public as possible, I encourage you not to repeat points that were made by previous speakers. And to allow the commission the time needed to deliberate on the important topics that I'll be discussing today, we will be limiting public comments to 3 minutes per person. Please note that staff will have an on-screen countdown timer visible to all attendees during the duration of your public comment. If you cannot see the timer and want us to tell you when you have 30 seconds remaining, please let us know in the beginning. Before I get into the logistics of raising the hands, I just want to do a quick review for both the commission and for the folks in attendance. We've now spent 17 months starting in July of 2021, learning, engaging, inquiring, and questioning a multitude of information that resulted in the motions contained in the draft report, which was sent out for 30 days public comment. We received 1,400 comments from 867 individuals. The staff put together a dashboard, which was linked to today's agenda of all of the comments for folks to review. Today, we'll discuss the recommendations for the commission's consideration related to the overarching themes found in the comments. Staff recommends the commission discuss the comments, make clarifying motions, amend the commission's original report. Amended report will then be submitted to the Board of Trustees and then to the Supreme Court. With that, I will now open it up for public comment. Devin, is there anybody that wishes to make public comment?
Our first public comment will be from Benjamin Cohn.
Hello, thank you, and good morning. I wanted to address what I think was an under-analyzed topic in the report, but was definitely discussed at some of your meetings, which is the potential to offer the bar exam more than 2 times per year in July and February. This is not an issue that's just of convenience to the and flexibility to the applicants in their studies and timing relative to job offers. This is an issue of operational integrity. At the moment, there are a lot of things that could go wrong. Some of the things are not the applicant's fault. Some of the things are even caused by various things that go wrong on the state bar's end, whether it's exam software, implementation of testing accommodations, proctors and reasonable testing accommodation denials, any number of things. And right now, there doesn't seem to be a remedy for a makeup or a retake, but 6 months causes a lot of permanent career damage, and having something maybe be 3 months maybe makes that less permanent, makes it more of just a delay. So that should definitely be, since you did talk about offering it more per year, I would like to see that represented more in the report. The second thing is I think there should be more discussion of changed parameters. There's already talk of raised exam fees in the Office of Admissions and Committee of Bar Examiners, and those increases probably don't reflect what they would need to be able to actually make the bar exam viable. So the non-exam pathway, I think, needs to address some of the not just current but forthcoming down the road budget changes in the report. And if there's not a clear motion, and I don't think there was, to not recommend a non-exam pathway, making a lot of recommendations about exam pathway without any discussion that the court take up, without necessarily endorsing the non-exam pathway, does seem to implicitly imply a recommendation to the court that they don't consider a non-exam pathway. And I don't think that's what the majority of you voted for. I think it should be, there's no endorsement one way or the other, but we explicitly want the court to look at the underlying discussions and analysis we heard. And so I think that that should be included too. Thank you. That's all.
Thank you. Our next public comment will be from Raymond Hayden.
Thank you, Ray Hayden here. And on the Blue Ribbon Commission, those who had been hardcore exam supporters did some surprising things. While they failed to accept the alternative pathway, they also supported the suggestion that other jurisdiction attorney applicants should be allowed to enter the California bar without sitting for the bar exam. They also failed to insist on ensuring that all California bar members are granted reciprocity, not just the ABA grads, but any Cal Bar admitted attorneys. California has a unique opportunity, which I refer to as the California option of studying law. This allows, in part, a solid number of us to actually participate in a law study program, which can qualify us to sit for a bar exam. It just happens to be the California bar exam. The penalty for our efforts is that many of us who are successful business owners, high-level managers, or professionals in other fields must pass the California bar exam first in order to qualify, in part, to then sit for some other jurisdiction's bar exam. Gaining full reciprocity for all forms of California admitted attorneys would free us from the additional burdens of having to sit for multiple bar exams. Now, I read Dean Gardena's dissent and the letter from non-ABA attorneys, and I agree that every lawyer should be treated equally in terms of reciprocity. Now, while I advise not to bring this up, I'm going to do it anyway. I'm going to ask it, nods of the heads will work. If my comments, my written comments made it in time to get to anybody, and it doesn't seem like they have. All right, so anyways, I have a program and okay, I got shut off. Okay, I don't know if you can still hear me. Can you still hear me? All right, good. I can't hear me, so lucky for me. Anyway, so the situation is I have a program of study which includes exams and testings which require a 100% perfection, no scaling required. You have to get everything right, 100% over a course of a program that can be issued in the portal of the California Bar Exam. That's in my written comments, and I'll be making these comments to other meetings as well. This can save millions and millions of dollars for the California Bar in the admission shortfall of the current $7 million that they have today. With that, I'm going to cut this short at this point. I'll be making those comments in writing and in other comments and other meetings with the California Bar. Thank you for your time and good work. Thank you.
Thank you. We have no additional public comments. Oh, we have someone that just raised their hand. Kendra Mueller.
Hello, thank you. Good morning to everybody. I'm commenting on behalf of the Disability Rights California law firm. We also submitted public comment in written form, and our analysis comes from both data, lived experience of attorneys, and then many bar applicants that we hear from. The current proposal does not address the underlying issue of inequitable licensure pathways. We believe this to be a grave oversight without addressing the core issue of inequity within the bar structure itself, regardless of whether these small adjustments in subject matter is made, the pathway will remain inequitable. As displayed by the US Labor Bureau, Census, Stanford Research Statistics, and many others, the legal profession remains one of the least diverse careers in the nation. Thus, attorneys and oversight bodies such as the Commission should lead the push for equality. The state bar indicates a duty to provide legal services for marginalized populations. However, this is insincere unless those with actual lived experience are able to join the legal profession. The profession should be fully representative of the communities being served. It's very difficult to trust a system that continues to exclude marginalized communities, and this also deteriorates the trust communities have within the legal system. Many of the 1,400 comments themselves show a lack of knowledge surrounding equity, diversity, and inclusion in the field, which also emphasizes the need for further diversity. From scientific research, standardized tests such as the bar have been proven to fail in qualifying competency, and they also cause disparities. However, comments have conflated keeping high standards, which we agree with keeping the bar. It also fails to acknowledge that the bar system itself has historically failed to protect the public and provides plenty of room to license unqualified and unethical attorneys. These comments are contrary to the Commission's requirement that recommendations be open quote evidence-based, close quote. The Commission's current recommendations to swap one bar exam for another does little to address competency and will perpetuate inequity, which is hopefully the antithesis of this Commission's mission. Thank you for your consideration.
Thank you. We have no additional public comments.
Thank you, Devin. Thank you for the public comment. Let's begin with the agenda. I believe we need to approve the February 27th BRC meeting minutes first. Do I have a motion?
I move.
Second?
Second.
Seconded.
Thank you. Can we move to a roll call vote, please?
Yes. Susan Bakshian,
Approved.
David Boyd,
Approved.
Alex Chan,
Yes.
Charles Dugan,
Approved.
Jeremy Evans, Jackie Gardina,
Approved.
Ryan Harrison, Dr. Henderson, Esther Lynn, Tracy Montez, Judge Reeser, Natalie Rodriguez,
Approved.
Kristen Rossi,
Approved.
Emily Scavalletto,
Approved.
Karen Silverman,
Approved.
Mylin Spencer,
Approved.
Amy Williams, Joshua Pertula.
Approved.
With 11 yeses and 0 nos, the motion passes.
Thank you. Let's move to the first item of business. Audrey, are you going to be reporting on this? Who from staff is going to handle this item?
I can talk about the item. So after reviewing the public comment that we received, we sort of broke down the 3 key themes that we saw sort of rise from all the comments. The first thing is, what does a California specific exam mean? There were a lot of comments related to that. Are we recommending to not test federal law? The second key theme was, does the Blue Ribbon Commission recommend reciprocity or comity? And are there any restrictions as to law school type on that recommendation? And then there were a lot of comments about the bar exam topics. So the CAPA report, looking at excluding certain topics and adding administrative law was what the commission went with. But when the report went out for public comment, there were a lot of comments related to should we add certain topics back into the recommendation, and especially professional responsibility. So I think the good place to start, probably, Josh, would be talking about the idea of a California specific exam and making sure the commission is on the same page with that recommendation, meaning that federal law will be included.
Yeah, I mean, I also want to just state thank you for all the hard work, Audrey and bar staff in putting this together. It was a tremendous amount of public comment in a very short period of time. And you put together what you believe to be the larger themes, and we're going to go through those. I in no way want to limit our conversation. If there were other areas in which any members want to speak to, comments that resonated with them or otherwise, I want to make sure we cover those also today, but we are going to try to move through the themes that the staff found in reviewing the comments. Yeah, on the first one, you know, there seemed to be some confusion. I didn't have the same confusion. I thought it was pretty clear, both from the report and from our meetings, and the what would be the legislative history of that report, that we specifically discussed the need to create our own exam, a California specific exam that would cover both federal and California law. Some commentators seem to think that just by its name, I guess the semantics threw them, that we were only testing California law. And I think that there was just a desire to clarify that wasn't in some way also confusing to any other members of this commission. Hopefully we can move on from this one pretty quickly, but let's see, Emily.
So I also was not confused, but I understand if you say California specific, there's also like a New York specific exam, and that makes people think it's going to be just about New York law. So I guess I'm happy to entertain the motion that staff developed, but I do think it goes a little bit beyond the federal and California rules in Civ Pro and evidence. So while I'm happy to entertain that, I would also suggest having it be California administered exam rather than California specific exam. That if in the language of our report, to just switch out specific to the word administered, and if somebody likes a different word, that's fine. But because we may run into other topics that for which federal law or state law, like we're pulling from rather than just Civ Pro and evidence. So we could say, you know, move that the Blue Ribbon Commission recommends that the future California bar exam will include federal and California rules and codes in the California administered exam.
Thank you for mentioning that too. Because we did actually modify the motion a little to cover a little more than what's in so maybe once we show it, we can see if that meets your need as well.
Other comments? And maybe I'm just not following it completely. I'm trying to figure out how administered helps in that sense, and gets us where we need to be on this. I do agree that by putting in civil procedure and evidence, we're in the motion that probably is not broad enough for the statement that we would want to make, I believe. If folks feel like administered makes a difference in the motion, we can move forward with it. Donna?
Maybe it can be as simple as changing references from California specific exam to California developed exam.
I would think that would help. I look to fellow members of the commission for other thoughts on that. I think it would help. I do believe that if we do say it includes federal and California, I mean, I think we need to be very specific. The confusion seemed to be broad enough that we need to outline that we intend to have both federal and California law as part of the exam. Yeah, Jackie?
I agree with Donna. At least I thought the confusion could be abated by California developed versus adopting the national NCBE next gen test. And the California developed test would include both federal and state law, should hopefully alleviate concerns about it being California only.
Okay, Audrey, is there a motion that we want to look at now that would make those changes?
Yeah, so we did make it more broad, so please let's see if this meets that need. Can everyone see my screen?
Yeah, I mean, I guess I would ask, the first comment we had to do with whether or not we wanted to specifically have civ pro and evidence in the motion. Can you talk to?
That's the way the scope of the current exam is sort of explained now. Also including professional responsibility, but since we are going to talk about the topics a little later.
Emily?
I move that this go forward.
Oh, a second?
Second.
Okay, Devin, you want to take roll call?
Yes. Susan Bakshian,
Yes.
David Boyd,
Yes.
Alex Chan,
Yes.
Charles Dugan,
Yes.
Jeremy Evans, Jackie Gardina,
Yes.
Ryan Harrison, Dr. Henderson, Esther Lynn, Tracy Montez, Judge Reeser, Natalie Rodriguez,
Yes.
Kristen Rossi,
Yes.
Emily Scavalletto,
Yes.
Karen Silverman,
Yes.
Mylen Spencer,
Yes.
Amy Williams, Joshua Pertula.
Yes.
With 11 yeses and 0 nos, the motion passes.
I would be remiss not to mention the speed and unanimity in which we just moved. Okay, let's take the second topic, Audrey, that you guys identified. I believe it has to do with reciprocity. And
Yes.
if you don't mind just giving a quick review of what some of the comments were on that, and then we can discuss it.
Yes, so a lot of the comments were, what exactly was the commission recommending? Reciprocity, the two-way admission on motion, or accommodating maybe one way. And Amy, who did the presentation several months ago, has some refresher slides on that subject that I'm going to share, and she's going to go through, if that's all right.
Yes, thank you.
So good morning, everyone. As Audrey's noted, the reciprocity policy is the one that allows an attorney to be admitted on motion as long as that same privilege is offered to the corresponding jurisdiction. And comedy is one that allows somebody to be admitted without having to sit for the bar exam, despite not being afforded that same privilege. Right now, in approximately 44 states, licensed attorneys are able to become licensed in that state without having to take a bar exam and it's via either of these two policies, reciprocity or comedy. And so the comments that we received sounds like they wanted more specificity on which of these two policies the Blue Ribbon Commission is recommending. Is it recommending that the court adopt a reciprocity or policy or a comedy? And so that is, I think, what's up for discussion. So we can narrow that recommendation. And along with that, I think the other part that is of interest or potentially could help this recommendation is regardless of which of the policy, whether reciprocity or comedy, policy decisions required on what happens when a jurisdiction does not open its doors to non-ABA law school graduates. That is California willing to adopt either of these policies that limits that only to ABA law school graduates? One of the things we noted in the agenda item that was posted is that right now the majority of law school graduates in California receive their JDs from ABA law schools. When we looked at data between 2000 and 2021, approximately 88% of first-time bar takers come from ABA law schools. California law schools that are from ABA law schools. Only about 8.7% graduate from California accredited law schools and 3.5% from California registered law schools. So the issue here is that recommending that a reciprocity or comedy policy that accept all graduates from all types of law schools jeopardizes that privilege for most law school graduates in California. So it's a big consideration for this committee, for this commission to discuss. And here in this map, this outlines which of the jurisdictions are open right now to the various forms of admission on motion. So in this map, you can see that the red jurisdictions, they require that admission on motion, that applicants have their JDs from ABA law schools, and reciprocity is required. The blue jurisdictions also require that the JD comes from ABA law school. Reciprocity is not required. So these are comedy related policies that exist in those jurisdictions. The green jurisdictions do not require that admission on motion that JDs come from ABA law schools, and no reciprocity is required. The purple states do not require JDs from ABA law schools, and reciprocity is required. And the yellow states here, South Carolina and Hawaii, allow admission on motion and limit that to ABA law schools, and they don't have a position on either reciprocity or comedy. And lastly, the 5 orange states do not allow admission on motion altogether, which means all applicants and licensed attorneys must sit and pass that exam. So what does this mean for California? Again, regardless of whatever policy is recommended by the commission, I think a big consideration needs to consider what happens when a jurisdiction does not open its doors to non-ABA law school.
And Amy, just for some clarification, if this commission's recommendation was to include both ABA and non-ABA, then we would be asking to implement a more restrictive policy with probably less reciprocity than exists today.
Correct. It would limit that the ability to have reciprocity with some jurisdictions.
And folks, I think one of the things that happened for us was that we obviously had some pretty weighty issues that we went through, and unfortunately at our meetings, you know, reciprocity and comedy kind of never got the full time that it deserved. We could have had more dialogue, more discussion on them. And so I think in that it was a little confusing how it came out. And so I think we need some clarification here. The big piece, as I understand it, is whether or not we are including, you know, ABA, non-ABA in our recommendation. I will just give you some thoughts. In my personal thinking on it, I liked the idea that we are making a decision as a state of California, which we had for a while, to have non-ABA, and therefore we should do our best to make sure everybody is treated equally once they become attorneys in the state. The one thing that became difficult for me was, as I read this report, the percentages were so large, and to make a more restrictive rule or recommendation in this case would affect 88% of the people in a negative fashion, versus the 12, and that just was overwhelming. So with that, I open up to comments, other people's thoughts on how we can be more clear about this recommendation. Emily?
So I guess I have a clarifying question. So last meeting, the vote was to revise the requirement so that any out-of-state attorney can be admitted to California without sitting for the exam. Is that correct? No,
Yes, that's correct.
that is correct. So isn't this issue kind of moot? Or are we going to go revisit that recommendation?
The public comment suggests that, that the commission be more specific than that, just than the broad, let's allow out-of-state applicants the ability, out-of-state licensees, the ability to not have to sit for the exam. I think people want a position on whether the commission recommends either a comedy or reciprocity approach to allowing those attorneys, licensed attorneys to come practice in California, as well as what happens with non-ABA graduates in that process.
Okay, because I guess I am, because I voted no on the allowing any state attorney to come in without taking the exam because of this issue, right? Because we don't know what we're getting for that. Like, if we're just going to let any attorney come in, we don't have the ability to say whether it's reciprocity or comedy or whatever. We're just saying, come in, and then our people will just do their best. So I get now, maybe they're wanting clarification, but I think the clarification is, at least if we're sticking with what was approved last time, is we're not addressing this. So anyway, I obviously want to hear from y'all, but that was sort of, maybe I'm missing it. Thanks.
Donna, looks like you have a clarifying point. I'm going to
Yes.
jump. Yeah. one second.
So yeah, I would just note that I think my view was that it wasn't that the commission sort of decided in the way Emily is describing. It felt like the commission was silent, and due to lack of time or other things, because we kept sort of tacking this discussion on at the end of something else, and we didn't have a lot of time to spend. And it felt like the commission was really silent on the and in exchange for what? The commission was clear that they thought that there should be a relaxation of rules to allow other people to come in, but in exchange for what really wasn't discussed. And there was a significant amount of public comment that was strongly opposed to letting letting people in without sitting for the exam, unless there was reciprocity, unless California attorneys, and there were some comments that were very clear, ABA only, didn't matter to the commenter. If the reciprocity extended to non-ABA graduates, there were some commenters who were saying, as Josh, you had indicated earlier in your initial thinking, California has in fact adopted these other avenues, other pathways, because we think they are important and they are viable pathways to the practice of law, and therefore we should support those equally. So it felt to staff like we needed to close that loop and not be silent. We needed to give the court the thinking of the Blue Ribbon Commission on the end of that equation, and what when it comes to California attorneys.
Judge Rossi, I apologize. I skipped you to hear from Donna.
No, and that's fine, because what Donna had to say, I think helped frame, my thinking on this. And I guess I'm thinking somewhere along the lines of what Emily just said too, and that is that we really did tack this on to other conversations we were having at the end. And I don't know that we gave it the time and the thought that we should have. And it does seem like an important issue. And now when there's only 11 of us here, it seems like maybe now isn't the best time to be trying to speak as a group when we're not all here. And I guess the other part that concerns me is that there are so many other variables here, and that we can't we can't dictate what other states do with non-ABA law school grads. And we are one of 3 states that allows non-ABA law schools. And so we can say whatever we want, but other schools, other states, I'm sorry, may just say no to our thinking on it. And I don't know that I got the sense that we did not want to be more restrictive. And so I'm concerned that if we adopt a policy that says all California attorneys or nothing, that we are actually, to Josh's point, being more restrictive. So I guess overall what I'm saying is that I don't think we discussed it enough, that we ought to be trying to come up with the clarification that I think Dawn is right that we need.
Jackie?
I wrote in my dissent about this particular issue, and I feel strongly about it because I am the only voice on this particular commission. I think on the Board of Trustees within the State Bar of California and the Committee of Bar Examiners who actually accredits our schools, that is a voice for the 12%. And I am troubled that we are actually talking about it in terms of 88% and 12%, because those 12% matter. They're judges, they're elected officials, there are people in this state who are ethical, competent attorneys who you are suggesting perhaps don't deserve the same recognition by the state of California. I agree with Judge Rossi, we cannot dictate what another state does. But if the State Bar of California, who accredits the Cal accredited law schools, doesn't recognize the graduates of those law schools as equally competent and should be recognized by other states, if those states want us to recognize their attorneys, I've got a problem with that. Because in my mind, that's signaling to every graduate who, because of life circumstances, because of finances, because of family circumstances, chose a California accredited law school, that what the State Bar of California is saying is, yeah, but those 88% who could choose an ABA school shouldn't be restricted because of you. I'm troubled by the message that sends. I'm troubled that an institution that is dedicated to diversity within the legal profession would say to those institutions and graduates who probably reflect the diversity of California more than any ABA school within California, that your graduates aren't worthy of us stepping up and saying, once you pass our bar exam, you are equally competent, and we will say to any state out there, recognize all of our licensed attorneys who are in good standing, who's been practicing for whatever number of years, regardless of educational background. And I'm just troubled that we need to debate this issue in California. So I just want it on the record that I want reciprocity. I'd want full reciprocity that recognize that other states must recognize all of our attorneys regardless of educational background. And if they choose not to, fine, then their attorneys who want to practice in California will sit for the bar exam, just like our attorneys will need to sit for the bar exam in their state. That's a choice that each state makes independently, and I'm fine with that. But California, please stand up. Please recognize those people who go to school part-time while raising families and work full-time and still pass the bar exam and still enter the profession and are competent and skilled and ethical. And please stand up and say they should be recognized in the same way as those who attend an ABA law school.
Thank you. I mean, I believe, to Donna's point, and to touch on what Emily said earlier, I think what we did, and we can choose to continue to do that, is we made a broad statement that said that we would rather have folks from other states be able to join the California bar without having an exam. But we didn't get into, for the reasons that you can see, it's a very complex issue, whether or not ABA, non-ABA, reciprocity, and give guidelines on that. I'm in the same position. I'm not really sure our recommendation, that I have enough information to really dig into that recommendation. I hear Jackie personally and completely understand that argument, and it resonates with me. And as I said in the beginning, and then I sit on the other side and say, there's a large percentage of folks that will be cut out of other states. And we had some discussions very early on as a commission about the importance of being able to practice across state lines, and how that's the future, continues to be, and will be the future of the practice of law. And so this is something that I think is going to be, we're going to have to figure this out as a state of California. We need to decide today if we're ready to take a position, or if there's a policy position rather than a specific motion, what breadth it has, and how we can give a little bit of clarity. And maybe the clarity is that we're not ready to, but I think that's today's decision. Yeah, Susan.
Thanks, Josh. Just to, I want to echo Jackie's remarks. As a professor at an ABA law school, I do agree that once a person becomes licensed in California, drawing lines between who's who is not what we should be doing. But I also agree that we didn't have these discussions in enough detail, and I'm uncomfortable with any sort of clarifications today that clarify discussions that didn't happen or considerations that didn't happen. I hope that our broad statement that we did approve and was successful is enough for a next commission or for somebody else to continue the work, to work on the details that would be necessary for a proper and delineated and specific policy, and that it would include all of these issues: how graduates fare in other states, ABA schools, non-ABA schools, and all of those good things. But I want to echo Jackie's comment in particular, that to start drawing lines of distinction between various types of California admitted attorneys is a huge mistake.
Josh, would it be helpful if I shared from the report, the motion that we did pass?
Sure. I mean, I don't know if it'll be helpful, but please go ahead and share it. Alex?
Thanks, Chair. I think I would strongly advocate for the inclusion of non-ABA and California accredited schools in any outcome. And I think I resonate with all of you, which is that to exclude these schools from our consideration is a non-starter, at least for me. I think fairness and accessibility are the foundational principles of this DRC. And so excluding these schools in our position really runs afoul of this principle. And so if the BRC does decide to consider reciprocity, we should only consider those states that actually accept students in California accredited or non-accredited schools in return. Separately, my concern remains that there are states that allow law school graduates to practice without taking the bar exams. And the commission has already studied these states as part of the analysis of the non-exam pathway. I can't recommend that these graduates be permitted to practice in California without taking any bar exam. And so the only way to alleviate this is that they have to have certain number of experience, which I think is already reflected in the motion, in working as an attorney, either in their home state or the state from which they're moving. And by the way, I think this seems to be a requirement common in many of the states allowing admission on motion. And so I would personally recommend instituting this requirement that is agreeing to this motion as drafted as part of our recommendation on reciprocity.
Emily?
So if we do nothing today, our recommendation is going to be, we think that all California or all attorneys outside of the United States that have been practicing for a certain number of years and meet the ethical requirements do not have to sit for the bar exam. And again, I was the lone no on that because I don't think that's wise. But again, if that's what we're left with, and we're not going to touch comedy or reciprocity today, I don't know that as I'm hearing, I don't know that gets at everything, because I think that the recommendation, that motion really does give the issue away. Like, we're just going to say everybody comes in. If we can, though, do something today that says whether or not, if sort of the and also, we recommend that if we are going to open up the floodgates to people coming into without a bar exam, that it's either reciprocity or comedy. I think we could do that today. My own view is the same as Jackie's. If you're a licensed attorney in California, you should be able to be a licensed attorney in another state just like anybody else. It makes no difference. So that I don't know if there's people that don't feel that way that are here to vote, but I'd love to hear that.
So let's look at two things. One is I believe I have, and maybe I'm mistaken here, I have a little bit of a different reading of the motion that we passed last time. I think it was the word explore. Was that, Audrey, can you put it up again? I think the kicking of the can is kind of what we had done based on time and other things, which said, here's a policy that we kind of believe in. Let's see if we have an opportunity to move the needle at all on this, but we didn't really take a position around it. So I guess the question becomes, are we ready to, and this is what you were asking, Emily, are we ready to amend our motion based on the public comments, or the breadth of the motion and the fact that we were asking the Supreme Court to explore these issues, is that enough? And I don't know the answer. I mean, I like I said in the beginning, I absolutely agree. It's the first thing that we should do is figure out whether or not and how many states, and I would use the leverage that we can to get every attorney licensed in the state of California. The question becomes maybe more difficult at some point. Are we, and it sounds like we are, and that's, but I just want to lay it out there. Are we ready to throw in the towel if other states say, no, we're not going to give reciprocity? As of right now, there are only a few states that would be willing to do that with us. But I don't know how hard we've pushed, and maybe Amy can talk about that a little bit, whether or not we've had discussions with other states or whether it's even relevant. So for us to get to a more specific motion today, I'm concerned that I don't have enough information to do that. So I think I would rather stick with what we have, which I believe is broader, but Emily, you seem to think that maybe it's not.
Yeah, I don't think we're exploring. I literally think that the motion says we recommend that the Supreme Court change the rules to allow out-of-state attorneys to enter with a certain amount of years of practice rather than the bar exam. That's literally what that first sentence says. So again, like, if it's fine if that's what the commission's going with, but like coming back now and saying we want to revise that, I'm all for it. I was before. But I get that maybe it's a lot for people to do now.
Jackie?
What I would like to see added to that motion, I'm sorry, Audrey, could you put it back up just so that I could add? In the first sentence, what I'd like to see, and this would be in line with the comments that came through and the clarification that was part of the public comment process, which is that first sentence to say that we recommend that the Supreme Court revise the requirements for licensed out-of-state attorneys to be admitted to California without sitting for the California bar exam to the extent the state in which they're licensed gives the same privileges to all California attorneys, regardless of educational background.
I'm going to stop sharing for 1 second so I can capture what I can't write into this PDF.
And I think for me, when we're talking about the damage that could be done to attorneys, right now, all California attorneys have to sit for another state's bar exam because we lack reciprocity. So what this would do is open the door to more states. It's not going to open the door to all states, but it's going to open the door to more states. But to me, it's important for the BRC to take a stand regarding treating all licensed attorneys equally, who are skilled, competent, and ethical.
Jackie, can you repeat the addition?
I'm sorry.
Application that you wanted to make?
Yeah, so revise without sitting for the California bar exam, to the extent the licensing state provides the same privileges to California attorneys regardless of educational background. Obviously, the state can set years of practice, all those kinds of things. That's not, but this is about the educational background piece.
Other comments, thoughts? Emily?
So I'm sorry, just this might be a clarification for Amy. So if there are already states that allow any of our California licensed attorneys to waive or to be in without an exam, that would also, even if it's comedy, that would also count towards this, correct? So we're talking about any state where the other licensee can, that state can allow our folks to waive in.
So any other state that allows our law school graduates to be admitted without having to sit and pass the bar exam is the reciprocity model. Is that what you're asking, Emily?
Well, there's also, I mean, we may not have like, I guess it's the same thing. So if there's states that are just like, yes, come on in, we don't care, but we don't let them come in.
Mhm.
Right. What we're saying, I guess, is that we will let them come in, and that is therefore reciprocity.
Mhm.
So I guess I'm sorry, I'm just trying to get the language down. All that we're creating is a reciprocity system within California, because we've not had that before.
Yeah, we're one of the orange.
Yeah. Okay.
Yeah.
But
Thank you.
just to be clear, in what we're asking in colors, are we saying that we are we would be turning to green or
We'd be turning to purple.
The purple, yeah.
is that right?
Open to non-ABA law school and reciprocity required.
Yeah, I don't think we're okay.
Or is that, I'm sorry, maybe that's not what Jackie was recommending.
David?
To go back to the recommendation as it exists at the moment, I'm got some issue with the way that first sentence is being interpreted. I don't read that to say that to be a recommendation that the Supreme Court allow all out-of-state attorneys to be admitted to California without sitting for the California bar exam. I think what it says is that the Supreme Court should revise the requirements about that subject. I don't read it at all like Emily does, respectfully. I think all this says is the Supreme Court ought to look again at our requirements for out-of-state attorneys to be admitted without sitting for the exam, which I think, Josh, is consistent with your view of how we ought to go forward.
And I think the reason the motion was written this way is because a policy change would require changing the rules, the licensing rules. And that is what's reflected here is that the Supreme Court consider revising the licensing rules in order to adopt this kind of policy. That would be a basic requirement.
That's my point. Thank you.
Okay, so Josh, I want to get back to another point about what the state of a comedy or reciprocity policy is right today. You know, we've been talking about reciprocity and comedy, but there is really a third alternative that most jurisdictions function in, and that is a third way that attorneys are allowed into another jurisdiction without having to pass a bar exam is this portability. And it happens with the UBE states. And maybe I could show you that map right now. And that is the prevalent practice that people, let me share my screen. Give me 1 second. That is a prevalent policy or method that is, oops, here we go. If you can see this map here, this is the number of states that are in orange that are UBE states. And portability allows people to port their score from one jurisdiction to another. And by that method are able to be licensed in another jurisdiction without having to take the bar exam. And so take it and pass the bar exam. And so the issue here is that this is a prevalent practice compared to comedy or reciprocity. And as a non-UBE jurisdiction, you know, we would have to embrace a reciprocity and comedy. And given that we're not going to, the recommendation is not to proceed with the next gen exam, we would be in the same, we would need a reciprocity or comedy policy in order to be able to admit attorneys or for our licensed attorneys to practice in another jurisdiction without having to take the exam. So I want to point that out. So yeah, you were asking like, what is the current practice? And that's the current state of affairs.
So we discussed this at the time that we looked at UBE versus a California specific or administered exam. And I know everybody thought that portability was really important, but obviously we felt it more important to have a California administered and specific exam. So in doing that, we are no longer able to avail ourselves. And so we need to find another option. I have to say, this all feels incredibly premature to me because I do believe that there may be some other routes down the road, which might include dealing with UBE when we have our exam actually developed, wherein maybe there is a way to talk about our exam scoring versus UBE and towards portability. That's a long way off and we're not there, but I think that this is a really important issue for lots of reasons that the Supreme Court and the California Bar are going to have to continue to deal with to figure out and balance what we've discussed today. You know, important on both sides or all sides. I don't know how to look. If someone wants to make a motion, we can obviously see what kind of consensus we have. At the same time, if not, we will end up staying with what we currently have, or we can take alternative motions and move forward from there. Jackie?
I thought that I did offer some language that Audrey added to the thing. I don't know whether it's the best formulation of it, but it's a starting place.
Okay, Audrey, you want to show it? And then Jackie, if you want to let me know if this is a motion that you are making, and then we can ask for a second, we can ask for friendly amendments from there and see whether or not we have any kind of consensus.
Sorry, I'm
That's
getting
okay.
it.
And I think what my motion is attempting to do, and others can communicate in that in revising in our recommendation that the Supreme Court revise the requirements, that revision, we recommend that revision include essentially reciprocity. And that's simply a recommendation from the BRC. And then also we're suggesting that they look at other things within that, but
Jackie, is this the motion that you're making?
It is.
Okay, great. Is there?
Steve,
Yep.
Sorry, educational background versus law school type. Jackie, do you have?
I think agnostic on that. So yeah. I don't know how that would affect the law study people. So I don't
Okay,
know whether educational background might be better.
good point.
Yeah, I think you have to keep educational background if you want to include law study for the same exact
Mhm.
reasons that Jackie, you're arguing to include
Yeah.
all
Yep.
possible types.
Good point.
Let's see if we have a second, and then from there we can open up discussion before a vote. Is there a second?
I'll second.
Okay. Comments, thoughts on this motion in the second? Friendly amendments? Susan?
I wonder if, I have no objection to this particular language, but my concern or my sort of comment would be, do we want to address the public comment and the public issue, which was a broader question than just this? Do we want to address it more specifically in line with the kinds of things that were in our initial motion? Our initial motion was about recommending revised requirements and then recommending an establishment of those requirements. I wonder if the way we should amend this is not to tweak the center of the motion, but to add a clarification at the end that says something along the lines of the BRC encourages that any revised requirements or any changes to establishing the requirements in terms of comity or reciprocity policies, recognize that all educational backgrounds be treated similarly. Something that's a little bit more to the whole policy than to just a modification of the first component.
Jackie?
To me, that changes it. The first sentence for me is a specific recommendation. The second one is more of an encouragement to look at a variety of things. We also are, in my mind, the first sentence speaks to reciprocity because it requires the other state. The second sentence includes comity or reciprocity. So comity is different and wouldn't provide the same, I think, clarity. So I don't accept this as a friendly amendment.
Thank you. Alex?
I'm fine with the amendments. The only issue I have, and the more I'm reading this, the more I feel like, there are two separate recommendations that are now combined in a single motion, right? The first part of the recommendation is that, well, we recommend reciprocity, but the second part of that now recommends in establishing those requirements, there's going to be a minimum number of years of recent practice. My understanding, at least when I voted on this motion, I was under the impression that as part of the reciprocity recommendation, that there are going to be strings attached. And the string here being that there's going to be a minimum number of years of recent practice. They're not separate recommendation in my book. If we were to recommend reciprocity, that reciprocity has to be based on also the number of years of recent practice in another state. And so I don't know if this is something that Jackie is willing to consider, but my recommendation and my friendly amendment to this would be something along the lines of, and at the end of the highlighted portion, regardless of educational background, I would add something like, and upon which certain number of years of recent practice. And so you can delete everything from establishing requirements and it's for the minimum, that upon which certain number of years of recent practice be required in another state, and everything else should be the same as what we have now. So literally all I'm asking or all I'm recommending is strike out the period and then everything after that period all the way up until the minimum number of experience.
Alex, if I'm understanding you, you are you want to put the emphasis on the experience as the litmus test that's being made here and remove the education from it. So it's reciprocity based on experience.
Correct, because otherwise this is a no, again, the concern remains that now we're allowing, graduates who have never taken a bar exam in those states that don't require a bar exam to now practice in California, assuming reciprocity is allowed in those states. I don't think that's something that we ever, as a commission, acquiesced or consented to. And so that's why I'm trying to tie those two things together as not a separate recommendation, but as part of the overall recommendation on reciprocity.
Jackie?
And I think, Josh, I was understanding Alex differently. You said to not put the emphasis on educational background, but on years of practice. And what I understood was it was both and, that the reciprocity should be without regards to educational background and upon which a certain number of years of recent practice is required. So I saw them as both.
I do too. If I misspoke, that was what I meant to say. That it wasn't, we weren't going to just focus on educational background. That's completely, we understand from your statement, it's regardless of, but nevertheless, you also need a certain number of years of practice is how I read it.
Yes, and so I would accept that as a friendly amendment.
Alex, do I have it the way you were describing?
Yeah, you have it.
Okay, good.
Other thoughts, Karen?
I just want to add a potential additional friendly amendment. Do we need to establish that they're in good standing in the other state? I mean, it seems to me that we should have some basic construct around that.
And it seems so, oh, sorry, can I?
Yeah, please.
It seems like if we took out the BRC recommends all the way through to along with demonstration of ethical and competent practice, it would achieve that. Would that achieve that, Karen? So that it's all, no, you keep along with demonstration of, and it could be good standing instead, but does that solve it for you? So it's all one recommendation of which ethical and competent practice is a requirement of the recommendation?
Yeah, and anything that makes it clear that it's all the things, not just, I think maybe I'm having the same problem with it that Alex was. I just want to make sure that it's a sort of a complete standard as opposed to pieces of a standard.
I guess the question is, along with the demonstration of ethical and competent practice, is that broad enough to include good standing for you, or do you want good standing specifically laid out in addition to that? Are you asking for that?
I think we should, at a minimum, require good standing in addition to that.
Do you want me to add out-of-state attorneys in good standing here, like this?
I think that's fine from my perspective. I just offer that to the group.
I'm comfortable with that amendment.
You want me to put
And
the second
perhaps-
sentence back in then?
1 second. Audrey, is it,
Yeah,
Alex,
we need the second sentence. This was sort of a different concept. As long as they're, like I said, it's connected.
And Karen sort of reminded me that there's also a moral character aspect of this, and perhaps this is subsumed in ethical and competent practice language, but I certainly would want this to be more explicit, that they have to demonstrate moral character. I don't know if there's any objection. Jackie, would you be willing to accept a friendly amendment to the extent that we include something along the lines of moral character, a demonstration of moral character?
Yeah, I'm assuming that that is subsumed within the requirement for licensure here within the state of California, even if the bar exam is not required. So it might be redundant, but I'm not opposed to it.
Yeah, moral character is just a term of art that is widely used. And so I just want to be explicit and not have to think about whether this is assumed or not. For us, clearly it seems to be subsumed, but I think from a general public perspective, I don't know if that's clear enough.
can I caution us against sort of listing out, 9/10 of the requirements for admission to the practice of law, because it sort of suggests, well, if we're listing moral character, but we didn't list that they have to be compliant with their child or family support orders, then therefore we're not requiring that. So I think maybe, right, the point here is all of the other requirements for admission to the practice of law still exist, but we're saying with regard to the issue of sitting for the bar exam, we're sort of imposing a different requirement, or we're imposing an exception to the requirement to sit for the bar exam. But I would caution us against sort of going too far down the road of listing out all of the rest of the components, because when we do that, and we miss something, there will be an implication that we intended to leave it out.
Susan?
I agree with Donna. I don't think we should include moral character for her reasons and for another. It's not common language used in other states. Other states use the term character and fitness. So I think to use our state specific term would also be problematic. And I believe that when we had these discussions originally, we did decide not to laundry list all of these things like moral character for good reasons, that they are independent requirements that we are not actually suggesting nor charged with making any changes to, and we should leave that be. That said, while I would leave moral character out, I would include both the good standing language and the ethical and competent practice language, because I believe those are distinct. You can be in good standing and never have practiced. So I think those two things belong in the motion for clarity, but I think moral character should not be included.
Alex, you have your hand up still. Do you have more comments?
Oh, no.
Okay. Let's just take stock in where we are as the motion currently sits. Jackie, does this comport with friendly amendment that you would accept?
It does.
Can we, just for clarity, get a second?
Second. Second.
Thank you. Any additional comments, or is the commission comfortable with a roll call vote at this point? Seeing none, Devin, let's go ahead and take roll.
Susan Bakshian,
Yes.
David Boyd,
I abstain.
Alex Chan,
Yes.
Charles Dugan,
Yes.
Jeremy Evans, Jackie Gardina,
Yes.
Ryan Harrison, Dr. Henderson,
Abstain.
Esther Lynn, Tracy Montez, Judge Reeser, Natalie Rodriguez,
Yes.
Kristen Rossi, Emily Scavalletto,
Yes.
Karen Silverman,
Yes.
Mylan Spencer, Amy Williams, Joshua Bertula,
No.
back to Kristen Rossi.
Yes.
With 8 yeses and 1 no, the motion passes.
Great, thank you, Devin. Okay, moving on, I think we have one more item that the staff laid out for us, and then obviously we'll open up to other items that the folks have they want to discuss. Audrey, do you want to take the last of the 3?
Yes, just as a refresher, I'm going to show the topics. I know we talked about this obviously at length, but it was a while ago. The topics that are currently on the bar exam and the CAPA recommendations that the Blue Ribbon Commission took up as their recommendations for subject areas to be tested. So the current bar exam subject areas, they're on the left, and then the CAPA recommendations, which became the Blue Ribbon recommendations as well, on the right.
So Audrey, let me just address this for a moment. There were some comments, as I understand it, that felt that we made a decision not to include ethics as a topic on the what we were recommending is the new bar exam. I don't feel like that was the decision necessarily we made. As we just talked about, there's a lot of crossover in what you need as requirements for the practice of law in the state of California. And we have other areas where ethics is actually tested. And so I think there was a little bit of confusion there. And my personal recommendation and suggestion would be that we make it clear that to the extent that ethics is not being tested in other areas, that it be included in the bar exam. And so I don't know if anyone else has any thoughts on that. I don't know if it makes any sense to repeat the same questions that they would people would be receiving under professional responsibility, as an example, but to the extent that there are topics within ethics that aren't tested, that we should absolutely include them in the bar exam. Alex?
Yeah, so my opinion on this is there are strong and vast differences between the ABA and California authorities in the context of professional responsibility. For example, from publication rights and loans and advances by lawyers to fee splitting and contingent fees. And so that this connect as a member of the CBE who helps put the exam together is that the CAPA study did not sufficiently consider the importance of these distinctions and simply concluded that testing ethics on NPRE would be equivalent for California examinees. Now, I looked at the CAPA report and it says as one of the reasons for recommending their removal is that the bar applicants must have earned a passing grade in at least one course in ethics that addresses the model rules of professional conduct. But most of these courses, at least to my knowledge as a CBE member, do not necessarily focus on California specific rules. And certainly courses from schools that are outside of California, say in New York or Texas, have no legitimate reason to teach California specific rules either. And so in my humble opinion, the CAPA recommendation undermines the importance of the California rules of professional conduct, or what we call CRPC. But separately, the CAPA report also overlooks the California State Bar Act, which interestingly also establishes additional ethical mandates on things like fees agreements, advertising, solicitation, and even unauthorized practice of law, all of which cover supplemental rules in California that are not tested in NPRE or covered by law school courses. And so my concern remains that removing professional responsibility would give bar examinees effectively a pass through to prioritizing the bar exam study in other subject areas over ethical rules that are specific, important, and essential to California, particularly at a time when more regulation is needed to rein in unethical lawyers in view of all the recent state bar events that you read on the news. And now that the California Civility Task Force, to my knowledge, also has put forth certain stability-related amendments to the CRPC, again, changes that I just don't believe will be tested by the NCBE on the NPRE, we as the commission really should be doing more and not less to close the knowledge gap between the ABA and California rules and ethics. And so I remain a strong dissenter in any effort to try to remove professional responsibility from the California bar exam. I yield back my time.
Other comments? Jackie?
I served on the CAPA. I think Alex's points are excellent, and I don't disagree with the substance of it. And I can't speak for the CAPA group, so I'm just going to speak from my memory of our discussion regarding this. And part of the discussion wasn't to eliminate exposure to the California rules, but that would it be better served to have a requirement regarding so many modules of California-based ethical rules that would be required for those either pre-licensure or right upon within the first 4 to 6 months of licensure that would be part of a state bar educational program. So I don't think CAPA, in my memory, was suggesting that there wouldn't be testing of or exposure to California specific, but rather that it would be done in an alternative manner. So I'll just put that out there. But I think Alex's points are well taken.
Emily?
So I'm the other CAPA member from on the commission, and I'm also going to just speak for myself. I have no problem keeping professional responsibility as a recommended subject matter. I think that at the time, as Jackie indicated, there are a lot of ways in which we test professional responsibility and ethics. I think that the fact that the scope of the bar exam tests both California and federal in that essay is different than the MPRE. And so it does make sense to keep testing that on California. So I would just say I have no problem if the commission decides, let's add that back into the subjects that we recommend.
Audrey, please, Dr. Henderson.
I'll just add that in the CAPA discussions, there was concern as well about the testability of ethics, that questions that assess the ability to make ethical decisions and apply ethics appropriately are often not very psychometrically strong. And so have limited measurement quality. That was part of the discussion that they made as well.
Audrey, do you want to share the motion at this point?
Yeah, and I made a couple tweaks based on some of what Alex was saying, which is based on how we currently test. So let me share this.
I think in our comments, it seems like we, as a group, understand and are committed to it. Is there someone who'd like to make a motion?
So moved.
Seconded.
Any comments or thoughts? Or if not, we'll move to a roll call vote. Devin, can you take roll?
Susan Bakshian,
Yes.
David Boyd,
Yes.
Alex Chan,
Yes.
Charles Dugan,
Yes.
Jeremy Evans, Jackie Gardina,
Yes.
Ryan Harrison, Dr. Henderson,
Abstain.
Esther Lynn, Tracy Montez, Judge Reeser, Natalie Rodriguez,
Yes.
Kristen Rossi, Emily Scavalletto,
Yes.
Karen Silverman,
Yes.
Mylan Spencer, Amy Williams, Joshua Pertula,
Yes.
back to Kristen Rossi. With 9 yeses and 0 nos, the motion passes.
Great. Thank you, Devin. Okay, at this time, I'd like to open up the meeting to other issues that were raised in the public comment, if there are any that any individual commission member would like to raise to the group. We can do that now. Otherwise, we will move towards the closing of the meeting. Jackie.
I'm sorry, I feel like I'm that student at the end of class who said, yes, I do have a question. It's a multi-part one, and sit back and wait till I complete it. So I just want to put on the record again, I put it in my dissent, but I feel as if it's necessary to state it again. And it did come up in the public comments quite a bit, spoke about our discussions and recommendations or proposed recommendations regarding what I'm going to call an alternative pathway to licensure. Was often tagged as a non-exam pathway to licensure. In my dissent, I made a distinction between those two. And in fact, in our proposed motions, we made a distinction between a non-exam alternative versus an alternative pathway to licensure that may include an exam portion to actually establish that general basis of knowledge. I still believe that establishing general competence should include some kind of supervised practice pathway. I'm disappointed that the BRC ultimately, and again, going back to the specific motions, we never suggested that the state of California adopt an alternative pathway. We only encouraged an exploration of an alternative pathway. And I think California is losing out on really understanding how to better license professionals by not focusing on what are some alternatives that might be available. And I would welcome further discussion about that. I recognize that given who is or is not present today, that it would be challenging for us to revisit any of the motions. It just felt important for me not to allow a significant part of what the BRC discussed to go without comment at the end of the process.
Natalie?
I just second that wholeheartedly. I don't know if there's anything more that can be done, but it needed to be said. So thank you, Jackie.
Well, this is probably okay, go ahead, Susan.
Sorry, Josh, I'll be quick. I just want to also say I could not more wholeheartedly agree with Jackie. And yes, I consider it, as I stated in my dissent, a failing of the BRC that we were unable to agree on something as simple as exploration of an important alternative. And that in an extreme moment of irony, additional states, since our report issued and went out to public comment, have decided to pursue this more fully. And we have missed an opportunity here.
This is probably a good time to note that if you want to submit a dissent, sign on to a current dissent, revise your dissent that currently exists, you have until May 5th to do that. So you can get that information to the bar staff. Donna, did I misspeak?
No, not at all. I just wanted to, in that vein, be clear that at the time that the report went out for public comment, Alex Chan's, I'm sorry, I realized my video is not on. Alex Chan's comment was specifically listed as his own comment and not on behalf of the Committee of Bar Examiners, and it was a timing issue. Since that time, the Committee of Bar Examiners has in fact weighed in, and Alex has made a change to the language of his dissent to be clear that he is speaking on behalf of the Committee of Bar Examiners, and I just wanted to state that publicly.
Okay, thank you for that clarification. So now that we clarified our recommendations today, again, just procedurally, so we all understand, this is our final meeting. The report amended based on our recommendations will be presented to the Board of Trustees in mid-May and then forwarded on to the Supreme Court for consideration. Again, May 5th is the day in which you can make changes or add to your dissents if you so choose. With that, I just want to thank everyone. This is, I've said it before, and I think we all know, really difficult work. It's really nuanced work. We've spent 1.5 years doing it, hearing from a lot of different folks. You know, I don't disagree that there's some opportunities missed, but I also really appreciated the fact that everybody came, put the time in, the effort, and participated. And with that, I'm truly indebted to Justice Guerrero for what she did as the chair before I took over, and for all of you for your time and your effort. So with that, I say thank you. It is our final meeting. We will need a motion to close out the meeting.
Actually, I think under the new rules, we don't need one to adjourn. That was my mistake. Sorry, Josh.
Audrey, we did, we didn't.
I know things have changed in the last 17 months.
Well, and I just want to say before we do close out, the State Bar staff was absolutely phenomenal, especially pulling together the report and all of the comments. And I just want to just say, for purposes of public comment, so important that so many people were energized by this particular topic and chose to communicate with us about that. And hopefully what it did is made the report stronger, or at least inform what the Board of Trustees and Supreme Court will ultimately do. So thank you to the public as well.
And Josh, thank you so much for your being chair and stepping in. I mean, you have run a very wonderful ship. Thank you.
Yeah, thank you for saying that. All right, folks. With that, hopefully we will all meet at another time. I will say to the State Bar staff, you guys this has been a tremendous amount of work, and you've been fantastic throughout it. And I would really appreciate everything that you've done for this commission. So thank you. And with that, we will adjourn.
Thank you all.
Yeah.
Thanks, everyone.
Thank you, everyone.